Let's speak to Reitumetse Phiri, a legal expert now. Thank you for being with us, Mr. Phiri. And a lot of the questions I would have asked would have been about when the President would be obliged to release this to the public. But he has said it will be released within hours. So that deals with the legal obligation, the moral obligation. How above and beyond his legal obligation has he gone in that regard?
Yeah, I think he's really been very transparent in this particular instance. I think it really will deal with some of the concerns around the conflict of interest or potential conflict of interest that have been raised in the run-up to the release of this report. Insofar as the remedial action from the public protector was concerned, he's actually beaten that insofar as he's actually shared this report with the public way before sharing it with Parliament, and also before he's actually considered its contents fully and considered how he's going to implement the recommendations. So I think the President must be commended for continuing in the light of the transparency and openness that this commission has been about, and ensuring that whatever the acting Chief Justice has put in that first volume of the report, will have access to as South Africans at the same time as him, essentially.
And just explain to us now, the report is going to make findings and recommendations. How strong, how binding are those recommendations? And this whole argument came up when the public protector released a report and everyone was, it's recommendations. No, it's binding recommendations. But I understand this time it is the prerogative of the President to act or not act on what the acting Chief Justice says.
That's very correct. This is different from the public protector's process, who makes binding remedial actions. In the context of a commission of inquiry, the recommendations are made to the President, and then it's up to him to decide which ones he takes, which ones he implements, which ones he doesn't implement. However, there is an underlying principle within the law that he actually must act rationally and with a legal justification if he is going to implement recommendations or not implement recommendations. So if he decides, Justice Zondo decided X and he says, I'm not actually going to implement that, he's got to be able to justify that from a legal perspective as to why that would be the case. So in as much as he does have a prerogative, to the extent that he may not want to take all the recommendations on board and implement them, he will have to give some kind of a justification that's legally sound for that particular stance.
And what sort of detail do you expect in the non-governmental recommendations? Because I think it's important to always look at the companies that have been implicated in state capture. And we've already seen apologies from these big global auditing firms, McKinsey paying money back, apologies, Bain implicated. So say he believes that one of these companies should do more, should pay back the state more. Can he put a figure on that and they're obliged to consider it? Or will he more say a state arm has to look into that matter, or the prosecuting arm has to look into that matter, or the Hawks, somebody has to try and get more money back?
Yeah, I think when you look at the terms of reference of the Commission, my sense is that the recommendations and the findings are going to cover three broad themes, rather. The first is recommendations to government institutions, so that could be the NPA, that could be the Financial Intelligence Center, that could be, a bunch of institutions that were touched within the process of this inquiry around what actions to take to either go after people or strengthen their procedures. So, for instance, the Financial Intelligence Center, I'd expect that we'd see a few recommendations around how to flag suspicious transactions, etc. And then, we're going to see recommendations dealing with governance at state-owned institutions and state-owned departments. We heard the testimony around consistent failures in those departments. So I think we're going to see recommendations relating to the tendering process and how that can be strengthened to prevent an occurrence. And of course, we're going to see recommendations relating to the ethical conduct of, for instance, the executive and other people that are involved or were involved in the state capture project. So I think the recommendations in a whole will touch those three broad subjects, and some will be a lot more specific, but generally I think we'll find the type of recommendations that say, prosecution must be followed against XYZ, or steps must be taken to recoup monies from that person, or that kind of office must be collapsed because it's, it facilitates this kind of larceny, if you would.
All right, thank you so much for that explanation, Reitumetse Phiri, legal expert. And this is just moments after we heard that we as the South African public will be able to view the contents of the first part of the State Capture Inquiry report, which covers SAA, the likes of SARS and the New Age newspaper. That will be up on the President's website.